you're fine. Oh, sorry, I thought that was a little bright.
I'm just looking through all these exciting texts. You can't extend all this, but it's fine. Well, this is just going to be I'm not. Good. How are we on in terms of everybody? You know, as council support,
They're just giving everybody time.
Is the, what about,
Hey, Paul, this is Brent. How are you?
Good afternoon.
Good afternoon.
Participation information. For those of you participating virtually, thank you for working with us to allow this hearing to proceed while staying safe and following the COVID protocols. Many of you are watching the YouTube link, and we thank you for participating in this way. For those of you who are witnesses or potential parties to this process who are participating by Zoom, we want you to know the following information. Due to public record requirements, chat is turned off and is not available. You must remain on mute until it is your time to speak. This cuts down on feedback and background noise so everyone can hear. If you have a technology issue during this hearing, please email Caroline at Caroline Lafreniere at jacksonnc.org. Caroline Lafreniere at jacksonnc.org. I'm sure you can find her email address on the Planning Department website. All right. To begin, Heather, before I read this general information, do I go ahead and call the meeting open?
Yes, call the meeting to order. You have an agenda in front of you, but I think this is an old agenda, so number. Okay, so number 4 needs to be crossed off, but yes, you go ahead and call your regular meeting to order, and then we'll get back to hearing number 5.
Okay, thank you. I call this meeting of the Cashiers Area Planning Council meeting to order. We have a quorum. Does anyone have any additions to the agenda? Otherwise, can I have a motion to approve the agenda as it's been submitted?
We don't have a copy of the agenda.
That's what council wants.
Council?
Well, we're participating. We don't have a.
Not at this time. Could I have a motion to approve if there's not any additions to the agenda? Motion is second. Seconded. All in favor?
Aye.
Okay. Then could, if everyone's had a chance to review the minutes of the October 26th meeting, if I could get a motion to approve that, there's no additions. Seconded. Seconded. All in favor?
Aye.
Okay. All right, then moving on to what was item number 5 on the agenda presented to us, new business. the special use permit for Cashiers Village. Okay, I would like to call that quasi-judicial hearing for the special use permit open. Meeting open at this time. All right. So starting with general information. A quasi-judicial hearing is an evidentiary hearing where the Cashiers Area Planning Council will make a decision solely based on competent material and substantial evidence in the record. The record is all of the material and input that is presented to the council, including the application, exhibits, testimony, and related materials. The record may include some insufficient evidence, but the council may not base its decision on it. The procedure provided here are not meant to be binding rules, to be flexible guidance for the conduct of the hearing. Okay. Over the weekend, we received a motion to continue that has been presented to the county staff and to the council by Attorney John Noor on behalf of several parties who claim to have standing to participate in this hearing. Before proceeding further with the hearing, we will now hear the motion to continue. John, where are you? There you are, I see you.
Good afternoon. Can everyone hear me?
Yes, we can. At this time, please present your motion, your objection to notice of hearing and motion to continue.
I'll be happy to, Mr. Chair. Just for the record, the clients that I represent in regard to this motion are Ganasita Property Owners Association, Jean Mingy, the Chattooga Conservancy, Miss Yvonne Johnson, and Miss Laura Moser. This is our motion to continue. Were the council members provided with a written copy of this?
We were.
Our motion to continue is based on multiple grounds. The first is I was only retained at 4 o'clock on Friday in order to represent my clients and be prepared for this hearing today. The notice of hearing was provided at most 16 days ago, and this is through no fault of county staff, but it's virtually impossible for my clients to be prepared for a hearing of this magnitude involving the issues that are going to be considered by council with that amount of time to prepare. Having only been retained on Friday, I can tell you that I am just barely being able to review all of the materials that the council will have before it today. This is, based on my understanding, the largest development proposal that has ever been put forward for the Cashiers community. And in particular, it requires the evaluation of areas that involve potential landslide issues, traffic concerns, valuation issues for abutting property owners, as well as public safety and other issues that generally require expert testimony to be provided. And my clients have a right to be able to produce that evidence through expert witnesses, and quite simply cannot retain those experts within the amount of time that they've been given on notice for this hearing. I'm involved in several other projects in the Western North Carolina area, and I can tell you within the last 2 weeks that I've contacted over a dozen experts with backgrounds in the types of issues that this council will have to consider, and none of them were available to assist my clients as of today. And virtually all of them would not be available until mid to late January to provide that kind of evidence, which isn't uncommon in these kind of hearings, considering the depth of analysis that's required in order to provide a response to the development proposal. So the first basis for our request to continue is simply to provide us with adequate time to properly respond to the development proposal that's been put forward. We believe it's a due process concern for our clients to be able to present that evidence, and we'd ask for a reasonable amount of time to prepare that response and provide it at a noticed hearing to the council. The second reason we're asking for the continuance is because of, again, and I want to be clear, this is through no fault to staff. I think they've done the best they can in challenging times to try and set this meeting up in a way that is fair and safe. But for example, this hearing, I think, was noticed on October 30th. Since that time, the governor issued Executive Order 176, which changed the in-person or mass gathering limit from 25 to 10. So as I'm looking out over the room right now, I know I can count more than 10 folks, but under the governor's executive order, this meeting would be unlawful because of the COVID restrictions that are currently in place. Again, that was a decision that was made after staff noticed this hearing, and again, not their fault. But again, we're required to comply with that law. And the third basis for our request for additional time is based on the notice itself and the hearing format. In the notice and under North Carolina public meetings law requirements, you either have an in-person public hearing or you have a remote hearing. There's really not a hybrid option that's available. And in this situation, my understanding is that the council members are here in a physical place together. There appear to maybe be some members of the public in the room. I'm not exactly sure. And then I know there's at least, as I'm looking at the gallery view, maybe 15 to 20 individuals who maybe they're seeking standing. I know some of them are my clients who are participating remotely, which requires that each of the council members here, in the way that you're hearing me right now, you're participating in this hearing through a Zoom interface. That's an electronic interface. And under state law, that constitutes a remote meeting. And under the governor's emergency declaration, remote meetings can occur. But when they do, they require that the parties with standing consent to the remote meeting. And as we indicated in our applications and in the affidavits that were submitted this weekend, our clients are deeply concerned about some of the due process rights that are presented regarding a virtual hearing and do not consent to having this heard through a remote medium, at least at this point. We'd like the opportunity to work with the applicant and staff to make sure we have a firm handle on how information is being presented, how the board views witnesses, how the interface is being communicated and whether there's a delay in that communication for objection purposes, how information that's presented to you in paper is then shared with me and my clients so that for cross-examination purposes, we can be provided with the same information and the same opportunity to engage in this. And so because this is a remote meeting and my clients do not consent, the board is not, or excuse me, the council is not allowed under the emergency laws to proceed with a remote hearing absent that consent. I'm happy to answer any questions that the council might have related to the motion. I'll also say, for those who are wondering, well, how much time do you need, Mr. Noor? We've asked that this be set on the February hearing for the council. And the reason for that is, one, as I'd already mentioned, the availability of expert witnesses in the areas that we have due to COVID, due to the holiday season that's coming up, and general workloads, which based on my current practice, the folks in these areas of expertise have had a level of work that is just previously unheard of. And so their availability is significantly limited until that time. We're not asking also for any purpose of delay. I want to be clear about that. What we're asking for is so that we can have the same opportunity that, for example, staff had to review this project. My understanding is that this proposal was submitted in August or maybe September. My understanding is the staff report didn't come out until late October, which means it took staff at least a couple months to look through this proposal in order to give you the information that you're going to rely on. And so we're asking for essentially the same amount of time so that those neighbors with due process and property rights interests that are impacted by this hearing can be prepared in a fair way. I also think when the council is considering fairness, they should consider and maybe even ask the applicant how long it took them to put this development proposal together. My guess is it took months. And so if it takes months for the developer to put the information together, I don't think it's unreasonable for the neighbors who will have to live with the result of this decision and development, if it is approved, to have at least 60 days to assemble the experts they need in order to present their case to the council. Again, I'm happy to answer any questions you might have, and I'll leave it there for the moment.
Thank you very much, John. At this time, I think, council, it might be wise for us to hold our questions until we hear from attorney from the applicant and the counter attorney on the side, but what questions are not going to at that time. So at this time, I would ask Attorney Craig Justice, the attorney for the applicant, to present his response to this objection.
Thank you, Mr. Chairman.
Yeah. If you would speak from the podium and if you would wear your mask.
Good afternoon, council. My name is Craig Justice. I'm the lawyer attorney for the developer applicant. I'm a member of the Family Law Firm in Nashville. I've been practicing land use law for about 30 years now. You probably can't tell from my face or mouth. I'm 55 years old. I've been doing this work, like I said, for about 30 years. I know that oftentimes in these hearings, this is not unusual for those in opposition to want more time to collect experts to be able to throw rocks at our presentation and to oppose what we have. But it's not unusual that they want to undoubtedly kick the can down the road and hope that maybe through financing pressures or pressures relating to the sale of property, that the project will just die and go away. So this is not unusual request. It is very easy to throw out terms like due process and hope that that sticks. Now, we all know due process is a consequence of constitutional principles. What is a constitution of the U.S. and the Constitution of the state of North Carolina requires of these type of meetings? Now, we hope that our General Assembly, people that we elect, would understand what the Constitution requires when they set out the minimum requirements for notice. And it is a fact that the minimum requirements for how much notice you give has been a long-standing statutory thing, meaning the General Assembly has set out in the rules that they adopted as our law how much notice you give to people in a community. So the argument is not that we violated, the county has violated the process and notice that the General Assembly has required. They want to say that that is something however violates the constitutional rights they have. And I would just respectfully disagree. The General Assembly puts forth that notice of these type of hearings is a notice that has to be posted. Essentially, it's between 10 and 25 days. That is the notice for these type of hearings. And that's what the law requires. So the idea that this is violating the Constitution would mean that the state law is unconstitutional. So it is correct that the county hasn't done anything wrong because they followed state law in sending out notices. So with all due respect, the idea that this somehow violates due process rights is not a correct statement. Moving on to the idea that this violates a recent governor order about mass gatherings. We all would admit this is pretty weird. I've got a mask on, everybody's got a mask on. This is stressful for all of us. This is unusual. But I will say that Mr. Noor is just not correct about what the governor said about government doing their job. From the very beginning, when the governor set out orders that talked about mass gatherings, it was very clear that exempted from those requirements were the government in providing services to the public, including this council providing this service of reviewing this application. This event is actually excluded and exempt from the mass gathering requirements, and it has always been that way. So respectfully, there is no prohibition of having this meeting. Mr. Noor has said that, well, this violates what's called a remote hearing. That also is not correct. A remote hearing would be if all the council members, or at least one of you, were in fact remote with one another, meaning that you were not all in the same room. If you weren't all in the same room, the General Assembly allows you to participate with your other members remotely. That would be a remote hearing. But because you're all here together, it's not a remote meeting. Therefore, there's no requirement of having everyone who wants to object to have to consent to this. It's simply not the law. Mr. Norris says, well, people are participating virtually. I look up here and it looks like, you know, what you see sometimes with talk shows and of all these people on the screen. And God bless them for wanting to participate, and they should participate. But the reality is, there's a choice that was made for today's meeting. Y'all did a yeoman effort to find space that you can have an in-person meeting, and that you can afford those in opposition withstanding and the developer to get together with a flow of people in the same room. The reality is, our side is here. We traveled from various parts around the country to get here. We would be presenting all of our evidence to you in person. This is what we wanted to do. You have provided more process by allowing those who want to say no or to contest to say you don't have to come here, you can participate virtually. You've given more process to those people. But just because you've given more process to those people who want to contest, doesn't mean that because they've chosen not to be here, that they want to be up on the screen, should allow them the opportunity to now kick the can down the road and have this thing pushed off to when all of us can be in the same room together. Respectfully, it is a choice that has been made to hear virtually. You coordinated this to be in person. We're here with our evidence. Not one of our side will be participating up on the screen. We're all here. So, in terms of this idea of, well, let's continue it and let's give us enough time to be prepared. So, they throw out the idea of scheduling. I don't know how many people have developed or spent a lot of money investing in development. There's a lot of time constraints that affect the ability to move forward. And ultimately, your county commissioners have set rules for notice and getting together that follows the state law. And we're following that by having that meeting today. It should not be, let's put it off until everybody who's opposed is ready. That's not how it works. With all due respect, we're ready. We've been ready. We would respectfully ask to move forward. Because none of the points in the objection actually matches what state law or your county requires for these type of hearings. And we do not want the matter to be pushed off. With all due respect, we want to move forward. We believe we have a wonderful project to present. We're ready. And think about it, folks. We don't know what's around the corner with this pandemic. You hear about spikes that are occurring and that it may get worse before it gets better. Why push it off when we're all here ready to go, when it may be worse a month from now or 2 months from now? And then we're all talking about, well, let's do it virtually. Let's not get in the same room. And you heard Mr. Moore say he would take everybody who's in opposition to agree to that. Therefore, we will never get through if Mr. Moore is correct, and we still have this pandemic. Let's do business in this county when we have gotten together and we can conduct business, which is today. We don't know what tomorrow is going to bring. Thank you.
Thank you very much, sir.
If I may be heard in response, Mr. Chair, to some of those points that were made.
Just a second, sir. Just a second. Heather, you recommend letting him respond to this comment?
Yes, I think you're fine to do that, and then you, at the council might want to ask them questions, either of them questions, you're able to do that. I'm here to guide you, I have some information to add, but I'm also just here for your purposes to guide you in making this decision.
Okay. John, I'll let you respond, but if you would, make it brief.
I will be brief. I think Mr. Justice misconstrues our motion and the basis is for it. I'll first start with, he raised the point that somehow we're not challenging the actual notice. That's incorrect. In the motion, we point out that the notice is deficient. Specifically, by using an electronic format as part of this motion, state law explicitly requires that the board indicate in the notice a location and means for electronic viewing. That was not provided in this notice. Specifically, there is no location for someone who would want to view this electronically to go and see the hearing. The reason for that is that that is provided so that those who don't have access to a computer or other electronic device still have the ability to participate in a hearing. And because the notice doesn't include that, it violates state law. That's a statute, that's a requirement that every board under the public meetings law provide, and it wasn't included in this notice. So this isn't just some theoretical constitutional due process objection, it's an objection to the actual notice of hearing. Additionally, because the notice indicates that not everyone can attend, it is excluding a portion of the public from the actual meeting, which is also a violation of state law, and we cite to that statute in our brief. I'd also like to note the due process requirements and what's required. Again, these aren't theoretical. The opportunity to present information and meaningfully participate in the hearing is a constitutional protection. It is guaranteed to my clients. There is no way that I could be prepared in 3 days' time to present the type of information that this board needs to make its decision. That is an absolute due process issue. I'll also say, despite Mr. Justice's extensive experience in this field, he knows that in hearings like this, it is not at all uncommon that hearings could take multiple days over multiple months in order for the council to come to a conclusion that it's coming to, or being asked to determine. That's very standard in in large projects like this. I'll turn to the remote meeting statute in the that was referenced. Again, this isn't us saying, well, you should want our consent for this. This is what state law requires. And we cite to the exact statute in our motion that says, if you, the board, are participating through simultaneous communication, which the statute defines as any communication that is electronic or through electronic means, then this is a remote meeting. Yes, the applicant is there and the applicant's experts may be physically with you, but my clients. Hello?
Are you able to hear me?
I can now. I couldn't before. Forgive me.
I'm just wondering, are you going to just point back to like previous statutes that you pointed out in your initial motion?
No. And where I was going with that is Mr. Justice's interpretation of the remote statute has also been rejected by a Superior Court judge in Buncombe County, who entered a temporary restraining order that enjoined the Buncombe County Board of Adjustment from proceeding with a hearing very similar to the format of this hearing, because it was a remote, at least at that point, to protect the due process rights and constitutional rights of the parties in that case, to prevent them from going on with a hearing like this that would damage those rights. And so it's not just my opinion, but it's the opinion of a Superior Court judge on this issue as well.
I understand, but that was outlawed in your notice of objection.
I do believe that's the last paragraph in that objection, maybe number 17. It's in there. And then I'd also add, forgive me.
Points based on what Mr. Justice says that are not outlined in your notice of objection?
Yes, and that's where I'm getting. Yeah, I think he just raised the why question. Why should this? What would happen tomorrow if we don't do this? I'll use this as the perfect example. Had I attended the hearing today, I found out hours before submitting this brief that the daycare workers for my 2 children have tested positive for COVID. I was offered an opportunity to come to the room where you all are today as counsel for for my clients. And had I shown up today, I likely would have at least created a high incidence or a high chance of infecting those in this room by my presence. And so the reality here is that my clients are entitled to both a safe hearing and a legal hearing, and we would ask that we be given that opportunity.
Excuse me, that is also outlined in your notice of objection. So is there any way you could conclude this your rebuttal to Mr. Justice's comments?
I think probably it's best positioned to answer any questions council members might have at this point.
Okay.
But we obviously disagree with this assessment.
All right. Heather, are there any questions that you would like to ask either the attorney that is objecting or the attorney for the applicant, or anything that you would recommend that we as councilmen ask?
I have just one question. John, can you hear me? This is Heather Baker speaking.
I'm having a real hard time hearing you, Heather. I apologize. It's a little muffled.
I understand that you're talking closer to the mic. We have the podium mic, and it was creating an echo for those of you watching on YouTube, so we turned that off. But hopefully you can hear me. The one question I have for you, the Board of Adjustment hearing in Buncombe County, was the entire council present? Or was the entire Board of Adjustment present?
It was, yes.
The other questions I would ask from you all, if you have questions in particular for him or for Mr. Justice, he may have something as well, and then I have some comments for you as we walk through the process.
I have some facts from this Buncombe County case he talks about.
Okay, just a second, sir. Heather, I mean, are we going to go back and forth with them arguing this Buncombe County course? What do you recommend?
Well, it depends how you want to proceed. If you want the council to discuss, and then you can ask questions as it's relevant. I don't think the format comes into play as much right now. We need your motion to continue to make a decision on that.
Yeah, that is not weighing as centrally in my thought process at this point. I don't know about the other, I mean, would the other council like to hear more argument on the legality of this format of meeting? Yes versus no? No, I don't think that's what we're, so, thank you, Councilor.
I'm sorry, I couldn't hear what was being said. Forgive me.
What I said, John, was I asked the councilman for a consensus to see if they really are worried about the format of the meeting at this time to continue to hear this this request for continuance, and whether they wanted to hear some more facts about the Buncombe County case from the applicant's attorney. And the consensus was that we didn't want to hear as much about the legality of this exact format to hear and vote on this continuance at this time.
Thank you.
So, Heather, did you say you had some comments, or first you'd like to see if the council had any questions for either of the two attorneys?
First, let's see if you have any questions.
Okay. Councilman, are there any questions that you have thought of for either the attorney objecting or the applicant's attorney? All right, I can think of one. John, what professional experts do y'all intend to retain?
It's somewhat hard to answer that question considering I've had such little time to look at it. But aside from that, I think there definitely would be traffic experts. There would be at least perhaps a geologist related to landslide and stability concerns coming out of this. Obviously, real property experts in the context of valuation. One of the standards the board has to consider is a reduction in property value for abutting or adjoining property owners. We would need appraisals or a real estate agent to give that kind of testimony. In fact, it's required by state law that we have an expert in that area. So I would anticipate that those at least those three areas. I'd also know in stormwater, we would anticipate an expert in that area. One of my clients is the Chattooga Conservancy, whose role it is to maintain and improve water quality in the Chattooga River Basin, which is within, I think, several hundred feet of this proposed development in the upper river portion. So I would say at least those four areas, and forgive me that I can't be more certain, but I just haven't had enough time to review everything to give a comprehensive list.
John, would any of these experts be used to help argue the standing of any of your clients?
So the standing, I think we have, under the Mangum case, the Supreme Court case, I think our obligation for my clients is to allege standing at this point in the case. And I think our affidavits provide that basis for standing. Those experts are absolutely required, though, to prove standing, which we think has to happen at the hearing. So without those experts, we would not, for example, the board was to continue with this hearing in full, we would not be able to prove that standing without those. They're absolutely critical in proving that standing.
Thank you very much, John. All right. Any other questions for for Attorney John Moore, who is his clients that have made the objection, or for the applicant's attorney? I have a question for you, Mr. Justice. Will your client suffer any undue financial hardships from continuing this case?
I'll let my client speak to that. He's right here.
If we delay more than a month, yes, significant. If it's a month, it's insignificant.
Forgive me, I had a hard time hearing that.
The applicant spoke himself, and I asked the question of his attorney and said, will the applicant suffer any undue financial hardships from a continuance? And he has stated that if it is less than a month, he will not suffer any great hardships. If it is greater than a month, he will suffer a financial hardship.
With council permission, I'd like to respond to that whenever appropriate.
Go ahead, John.
Just briefly on that, one of the obligations that a developer or applicant has in this is to ensure that they have sufficient time under contract, if it's to purchase property or to finalize the development. Their obligation is to make sure they've ensured enough time under that contract so that this council has the ability to fully review the project. So I would encourage the council to not feel the burden of the developer's decision on the length of contract that they negotiated as your burden to make a quick decision. Your burden is to make the decision based on the information you have to consider, and you have as much time as you'd like to do that. And the developer could go back and extend their contract to negotiate for that. But you all are not required to make your decision within any given period of time.
Thank you, John.
Can I respond to that?
Yes, please.
So the argument that John wants to make is ultimately the time needed for the opposition to come up, and we're talking about February is what they said, to come up to a closed development project is the time that should be allowed. You asked my client, what are the pressure points? My client said 30 days. So at the end of the day, it's not how much time does the opposition need to come up with experts and to be prepared. Your county commissioner said, let's follow state law and provide the notices required. That is all the notice that's required for people to be prepared. So my client has offered up that 30 days is a breaking point. Mr. Noor is basically saying developers who want to come to Cashiers and invest in property here need to be prepared to have a flexible time frame that extends well into the future, as long as opposition is out there that wants to have more and more time to get ready. And that should not be the standard. And I would just respectfully ask, I know that Ms. Baker is a very fine county attorney, so a lot of these legal he said, she said things, I believe, Ms. Baker would have an opinion about whether he is right about state law or whether I'm right about state law.
Okay, thank you, sir. Heather, in light of these points, do you have any further bits of wisdom or direction for us?
I do want to point out a few things. One is, I do believe we are holding the meeting in a legal fashion. It's the only way we can do it in a time of COVID. The notice has to be sent out at least 10 days, but not more than 25 before hearing. And that was done. So that means that all of the parties who received notice had roughly 2 weeks, if that, of notice. So I understand Mr. Moore's argument that they don't have a lot of time. You cannot usually get your experts together in that time period. And as you'll hear, with regard to standing or with regard to being able to provide expert testimony that might refute what the situation, one thing this council wants to make sure, and one thing county staff always wants to ensure, is that when we're done, we have had a fair and impartial hearing. And sometimes that may mean a continuance. That is ultimately your decision to make. But that, just remember that information that, yeah, state law was complied with as far as notice, but that is 10 to 25 days, and that was sent, notice was sent as was stated on October 30th. Other things to consider, again, I do believe that the hearing is correct. All of you are here as council. We don't have any council participating remotely. Mr. Norris cited the law for remote meetings, but the law that was passed this summer by the legislature says that a remote meeting is when a member of the governing body is participating remotely, and that's not happening. All of you are here. You do have to provide the public a way to observe the hearing, not necessarily participate unless they have standing, but to observe. So with all the notices that were sent out, the YouTube link was sent out. We've got a lot of people watching today by YouTube. You can watch that anywhere, anytime. We did take into consideration those who may not have computers, those who may not have internet, and they have the option to call and allow us to find a place or a way to participate. And that's all the folks that are here today participated. They called, they got the application for standing, they were then sent the Zoom link, or they're here in person depending on their situation. So we complied with all of those elements, and I believe we would be upheld on that. So I think you are having a hearing in the correct way, in the correct format. The real decision before you is, are you going to allow the motion to continue? And I'm here to answer any questions on that that you may have.
Heather, how typical is granting a continuance when parties are allegedly standing in need of experts to argue, to qualify their standing, or to have expert witnesses to refute expert witnesses by an applicant? How typical is that?
Well, for our county, we don't have that happen very often because we're usually having small hearings. We don't have the complex hearings that we're having today with multiple parties and involving multiple experts. When that does happen in other jurisdictions, I do feel that is much more common because of the very situation. You have people that come in that do understand the process. You've heard before from many people that come and to present at a hearing and say, we didn't understand the process. We don't know what it is. We didn't know what we had to bring to show. You hear that over and over. And to understand and to do that, they really got to hire an attorney and then hire their own experts. And I think in those cases, it is common in jurisdictions that have this type of hearing on a regular basis to ask for that continuance, so they do have time to have their experts present.
Okay. Do any of the other councilmen have any questions for Heather as we consider whether or not to grant this continuance?
Who else can speak?
No one else.
So, Heather, and I respect everybody here as far as trying to present their case. Realistically, everybody has that here today appropriately, from what I'm understanding. And that realistically, unless we're going to allow them to bring in some experts 2 or 3 months down the road, then we probably should make a vote on whether we want to continue with this at this point right now.
That's fine. I mean, it's we can have a motion and a second to approve or to disapprove. So, if anyone would like to make that motion, I'm not going to at this point. Wait, excuse me, ma'am. Excuse me, ma'am. This is wait, ma'am. Wait, ma'am. Excuse me. I will explain. Okay, so this is like a court, and we're hearing this attorney, and we're discussing his standing. We are not to a part of the hearing where you're arguing for your standing or whatever role you have. We're just handling this matter in front of us.
I will add, Mr. Chairman, that if you have a vote, or if there is a motion and it's second, and it is open for discussion, just like Mr. Moore represents parties who allege to have standing, the parties here, the parties on Zoom are also parties that allege to have standing and may have something to say on this issue. I think as a chairman, as a council, you can limit that, but I think you can also open it up to others who are really in the same situation that Mr. Moore is in with his clients, where they fill out the application and have done the same thing as well.
How does the council feel on having other parties who we've not yet determined whether or not they have standing weighing in on this issue? Is this something that you'd like to have a motion, a second, and then open it up to discussion, and we could try to do that in an orderly way? Or is this something where we'd rather get down to it and vote on this motion? Anybody?
I don't object to it as long as it's orderly, and if it's 3 minutes per person, or I don't know how that
Okay.
works.
How do we feel about that? Second. So so what we need really to do that, there's kind of a feeling to do that, we can have, we need a motion, I believe, Heather, correct me if I'm wrong, a motion to approve or disapprove, a second, and then we would open that motion up to discussion, is that correct?
Motion to approve, the motion to continue with that?
Yes.
Yes.
Okay, would anyone like to make a motion on this matter?
Be specific.
Like, would you like to make a motion to grant the continuance, and then we'd have a second, and then we would consider whether or not to open it up for discussion?
I make that motion.
Motion to grant the continuance.
Grant the continuance.
Okay, is there a second?
I'll second.
Okay. So we have a motion and a second. Let's open it up to discussion. Are we for hearing some members that are alleged standing in an orderly manner, like being able to comment on this?
I see no reason not to. They have so much right.
Okay.
And that would include those on Zoom as well, or on the same position as those who are here that were just willing to participate by Zoom, right?
Okay. So there are several people. Is it correct that there are 30 people on the Zoom call, Caroline?
There are 22.
There are 22 people on the Zoom call, and there are, I don't know, roughly 15 people here. So having heard from Mr. John Moore and Mr. Craig Justice, first let me start with parties in the room, limiting the comments to no more than 2 minutes. I'd really just like to hear like a short version of this and not get into the whole bit. I don't want to hear your arguments for or against the project. It would be why a continuance is relevant to your asserting standing or being able to hire an expert, which would be like an appraiser or an engineer that would argue your case at a further date before we can grant the continuance. Is there anybody that would like to speak briefly in that matter that's here in the room? I see 3 hands. All right. Ma'am, your name?
Anita Kramer.
Okay, if you would stand and speak from the podium briefly.
And this is just regarding the continuance.
Yes.
Yes, my name is Anita Kramer, and I am the adjacent property owner to this development. My address is 298 Monte Vista Road. That's they're going to use that for their back entrance, so I do have standing. I just got this letter. It was sent to me on the 30th. We need more time to understand. This is the magnitude of this proposed development will have permanent, long-term detrimental effects on everyone in Cashiers except for the developer. Nothing like this has ever been proposed here, and there are reasons for that. I haven't seen the long-term use plan recently, but the comprehensive plan, we never had this type of development. So we just need time to come together to negotiate, to make it.
Just a second, ma'am.
I believe the matter is not to the merits of the proposal, but to the reasons why it should be continuous. And so there are reasons I have to object to this testimony on the substantive thing.
Yes.
I'd rather not do that. I'm only doing the procedural thing. So I respectfully, I think that's a little off track.
So ma'am, what he's saying is, if you could keep your comments about the project, about the size of the project, about the uniqueness of the project, just.
Later time.
Yeah, later time. So, for a later date, would you consider hiring an expert to validate your standing?
I am trying to hire an attorney. I absolutely would like to prepare and even join some other community members, citizens, who have, this is going to impact their lives forever. So yeah, we just need more time. And I don't know why they want to rush it through when half the people that live here are gone to Florida or wherever.
Okay, I think you made your point.
Okay.
Consider hiring an attorney. I understand.
Yeah, this is.
I'm just trying to keep this orderly, so I think that's a good comment by you, and I just will move it on to the next person, if that's all right.
And 1 month or 2 months is not going to make him, miss the project.
Thank you very much.
But the whole community needs some more time.
Thank you.
Thank you, thank you.
Thank you. The second person I saw with their hand raised was Steve. Did you want to speak to whether you would hire an expert? All right, then if you would stand up and go to the podium.
Okay, just real quickly, in looking at this, it's really apparent that there needs to be a traffic analysis.
Okay, so, but
specifically, I'm going to run down a list of these things.
But are you going to be hiring these people?
Well, of course not. It's not my project.
But you're the party, like, so they have hired a traffic expert. So the point is.
Excuse me, can I finish my statement?
No, I'm just trying to keep it under control.
I have 2 minutes.
Heather, how do you, we're just figuring this out, Steve, just have patience.
I think it makes it fair to have 2 minutes, only talking to the motion to continue, not touching it on the side.
Yes.
Okay, and if you keep it that, Steve, I appreciate
Yes,
it.
the traffic analysis needs to be done as a part of this, and it's not just the analysis of the existing traffic, but take into account all of the development that's going on just south of town of Higham, over 400 new home sites. Second, we need time to do a wastewater runoff analysis because there's going to be a lot of runoff from this construction right in the center of town, and I'm not exactly sure where that's going to go into the lake. Third, we need property analysis will give us an impact on the valuation of our property and the real estate values. And finally, the economic impact and analysis on the local business as well as construction is underway. It'll probably be a 2, maybe 3-year project. It's not going to be a quick one. So we're going to have to deal with the side effects of this. So thank you. That's all I need to say, but I'd like to speak more on it.
Thank you, Steve. I know y'all, but everyone has a mask on, so at the beginning of your comments for the record, you can just say it now.
Matt Murray, and I have property that adjoins this property. This is a development, and this may not coincide or may interrupt me with what I have to say. Who is on the board? Could you raise your hand? How many members do we have?
We have 7 total members, 6 are present.
Okay, and then how informed, I just want to ask this question, are
Pat,
board members?
Pat,
No.
Pat, bullying. Wait, I'm not bullying.
Yes, you are. Do not interrupt me.
I assure you, I'm trying to keep this order.
Okay, this is what I want to know.
Wait a second.
I'm not talking to talk with me. I want to know how informed the board is about
Receive all the documents.
you are.
This is the beginning. Pat, please, if you just would work with me a second on this, okay?
Oh, absolutely. I want to read to you on this,
So
paperwork
just,
that I
can I
received.
just remind you what?
It is assumed and do not appear $100. It is assumed and do not appear. Are y'all aware of that? The verbiage throughout this.
All right.
So obviously this is not read. It is assumed. And
So
that's not appear.
So
So that's my question is the knowledge level for you to make a motion and for this board to make a motion.
Please, ma'am. But right now, what we are only discussing are comments and your thoughts regarding your need to have more time to hire expert witnesses to help question their expert witnesses.
And hire expert. Once I understand which experts I need, once I further understand, because I haven't had enough time to review this at all. And there's a lot of open-end things, like I said. There's verbiage in here. There is verbiage in here that the average person does not understand.
So
So I need someone to break down the verbiage so that I can better
So
understand.
you may need time to hire an attorney or some other expert.
Oh, yes, absolutely.
Okay, thank you.
We got that.
All right.
Mr. Chair, I hate to interrupt. I just wanted to note for the record, I didn't want to interrupt Pat, and I didn't catch her last name, but I was not able to really hear what was being said, but I just want to note that for the record.
All right, thank you. That's noted, John, and that was Pat Nardi. All right, now, Carolyn, what is the best way for the people that are alleging standing that are on the Zoom call to have their opportunity to make some 2-minute statement if any of them choose to? Should I go by a roll call, John?
Yeah, if you want to go down the list.
Okay.
I will ask them on the,
Okay, then we'll do it that way. All right, well, okay, number one on my list is Paul Lee Anderson, and I believe that he is a party to this objection to notice. So is he going to separately make a comment, Paul?
I can.
Oh, well, I mean, it's your choice.
Yes, a comment about the development or about the continuation?
About the continuation only.
Well, obviously, I'm president of, can I speak?
Paul, just a second. The county attorney's trying to say something.
Okay, sorry.
better just allow the attorney, I think, is already spoken for him, and to move on to those who are not represented and have not had someone speak on their behalf.
Okay. John, do you agree with that?
I do. I was about to say, I think I've represented Paul's interest in this in the argument that I made about the continuance, and we can save the council some time.
I'm sorry, I could not understand.
Are you fine accepting the advice of your counsel that he has already stated your interests?
Absolutely, 100%.
Okay, thank you very much, Paul. So then to clarify what I'm saying, let's hear from people that are not a party to this objection, and we'll have a chance to hear from all of them. Sarah Jennings, did you want to refer to, she's number 2 on my list, did you want to say anything in regard to this continuance?
No, thank you.
Okay. Brent J. Millis, it says that, are you a party to this notice of objection? Brent Millis, can you hear me? He was supposed to be the person. Okay, all right, I'm not getting a response from Brent, so we'll move on. Kelly Ryan. Kelly Ryan, can you hear me? Can you unmute yourself if you can hear me, Kelly? Okay, moving on to William H. Schofeller / Silverleaf Capital LLC.
No need to comment.
Okay, thank you. Number 6, Lisa Ullman. Lisa, would you like to make any comments?
So I think John Noor represents both Lisa and me. We're at 60 Watch Hill, but we clearly would like it to continue.
I see you there, thank you.
Just for clarity on the record, we haven't entered into a formal representation yet, but I think what the Ullmans may have been saying is they agree with the arguments that I made in representing their interests.
Okay, we'll note that, John, thank you.
Yes.
All right, Jamie and Mark Moran.
Paul Anderson speaks for us, as does John Noor. Thank you.
Thank you very much. Juliana Kaufman.
She's here.
Juliana. Hey, Juliana, would you like to add anything to this? Okay, all right, thank you. You've already had your chance because you're here. They've just given me how to understand this this spreadsheet. Thank you. All right, so Juliana, you're okay? No, just to have a chance to speak, but actually the people in the room, we already gave a chance to speak. I'm just learning how to use this spreadsheet that shows virtual versus in person. So I'm going to move on to Maria Partlow. Maria?
But you didn't listen to her. She raised her hand. She wants to continue. She wants to delay. She can't hear it very well. She also raised her hand.
Oh, I didn't notice it. Julia, I'm sorry, I didn't notice that you raised your hand earlier. If you'd like a chance to speak, you're for continuance? Thank you, ma'am. All right, Maria Partlow, a party that is here virtually. Maria, can you hear me? If so, unmute yourself. Okay, moving on to William Wallet and Susan Graham.
We agree with John Noor, and we're part of Paul Anderson's objections.
Thank you very much. Stephen W. Clark. No, he's not either virtual or in person on my list, sorry. Deborah Lentz Clark. If you can hear me, unmute yourself. Jeannie Menenge.
Mingy, can you hear me?
Excuse me, ma'am.
She can't hear. I'm having problems hearing and seeing.
Yes, ma'am.
But I have something to say.
No,
Just
no.
If I could. You want to continue? She does. I hear it.
Okay.
Okay.
Jeannie Menge.
Can you hear me?
Yes. Are you a party to this objection notice? Motion to continue?
I agree with John Noor. John Noor represents me.
Okay, thank you. Yvonne Johnson. I believe she might have been a party to this. Yvonne?
Yes, I'm here, and John Noor represents my interests.
Okay, thank you, ma'am. Robert Salveson and Suzanne Benaki.
Yes, we support the Noor motion and would add only that it seems to us that due process and everything else about this proceeding means that the people whose interests are being affected get treated with fundamental fairness. And we don't understand how people can be treated with fundamental fairness under these circumstances without the continuance.
Okay.
Thank you.
Thank you, sir. Sean Cronin. Sean, if you can hear me and you have anything to add, please unmute yourself. Okay, moving on. Robert.
Michael, could I just say Kelly Ryan was unable to get on the Zoom call, and she's watching by YouTube. She is a neighbor to our association. I know I can't claim that she is with
Okay.
Miss. Oh, wait a minute. She's on. She just got on. Very good.
Have anything to add? Please unmute yourself. Kelly, you're a part of the Gonacita Association and part of that group.
Yes.
Okay, so you're
Michael, can I just say Kelly Ryan was unable to get on the Zoom call, and she's watching by YouTube.
I think we're going through a delay right now.
She is a neighbor to our association. I know I can't claim that she is.
Can we mute?
Oh, wait a minute. She's on. She just got on. Very good.
Okay. All right.
Yes.
Okay. So
Michael, can I just say Kelly Ryan?
Everybody stop talking.
She's watching by YouTube. She is a neighbor to our association. I know I can't claim.
Okay. Kelly, there seems to be some problem with your audio where we're getting like delayed feedback, but it's our understanding that you're a party of that Ganasita action? So if you nod your head yes, all right, now you're off the call, okay. All right, moving on, Robert Goldman / Wade Hampton is what is listed. Robert? Okay, moving on to Connie L. Hawkins and B. Keevan Hawkins. Keevan, do you have anything to add to the discussion of the motion?
I agree. Can you hear me?
Yes.
I agree with the motion. I'm not represented by Mr. Noor, but I was given a questionnaire only today asking if we would suffer damages and to list them completely. I only officially received the plans, and I'm not speaking on the merits of the plans, but I am speaking to Mr. Noor's objection. This questionnaire asked me for specifics about damages, and my response was, I don't really know because I haven't had a chance to look at what damages there would be, if any, and whether I would want to join in with the objection. But it seems that this property has been in question many times, and the last time the question was for the cell tower, if we all remember that. That took a process of months just for a cell tower. And I would encourage the council to take that into consideration for the enormity and scale of this project. Because we really need to, as butters and standing, to evaluate whether or not we would, quote, suffer specific damages. I couldn't answer that question today, and I feel that we need to have some
Keevan, I think your audio is dropped out, but what I'm hearing is that you feel that you're in favor of the continuance and that you could use more time to prepare. That's good. Okay, moving on then. Nicole Haler of Chautauqua Conservancy. Is she part of this?
She's represented by myself, Mr. Chair.
Okay, thank you, John. All right, moving on to Maria Hotelling. Excuse me, Mary Hotelling. Mary, if you'd like to add anything, please unmute yourself. Okay. Moving on, I believe next on my list is Laura Moser, and I believe she's a party to this. She's a party to this motion to continue. Is that correct, John?
She is, Mr. Chair.
That's correct.
Thank you. Next on my list is Robert Wood. Rob, can you hear me?
Yes, thank you, Michael. Yes, thank you, Michael. I agree with the motion to continue.
Okay, thank you. I have next on my list a Mary Ellis. All right, just a second, Mary. We're getting you on. Mary, can you hear me?
Yeah, I agree with the argument John Noor made for a continuance. And I'd also like to comment that this virtual format is very frustrating. I often cannot hear the speakers in the council room there, and I'm losing internet, and it's just very, very difficult.
Okay, thank you, ma'am. It's noted. All right, and last on my list is John, so I believe that we've heard from everyone. So is there any further discussion amongst the councilmen, or shall we, based on what we've just heard from these parties that are alleging standing, or is it time that we go ahead and, if someone would please read back the motion. It was a motion to grant the continuance, I believe. Yes, it was. Okay, so at this time, is there any more discussion? Okay. Also, procedurally, Heather, I believe that you said votes in this meeting would need to be what do you call it, 4 out of 7 of the council, even though there's only 6 council members here.
Well, that's your vote on the final project, or whether it's approved, denied, or approved and not. This would need to be a majority, but a majority is 4, so you're in good shape.
It's the same.
Yes, but you might want to roll call, for members, so that everybody can hear clearly the vote.
Go ahead.
I'd like to make a suggestion. If we're making a motion to put this on to a later date, as far as that goes, I'd like to try to consider.
Just speak up.
Cannot hear, I apologize.
If we're making a motion to push this off to a later date, I'm making a suggestion that we put this off for a 30-day period of time to allow them to seek their experts such as geo, traffic, stormwater, and those types of things that they were suggesting, real property, if it was going to affect the values of those properties.
So that's a good point, Heather. How does this go procedurally? Do we vote to grant or deny the continuance? And if so, if we were to grant the continuance, the vote to grant the continuance, at what time would we handle the logistics? That's not handled within the vote itself.
I would have to vote first, and then we'll need to have a discussion about the continuance date would be the next step, because there are several factors that are going to weigh into that.
Understood. Okay. So in light of that, if there's no further discussion, I'm going to go councilman by councilman that's here, and you'll vote in the affirmative to grant a continuance or against. Is that correct?
Correct.
Okay. Mark, I'm going to start for you. Are you going to vote to grant this continuance or to deny it?
Grant continuance.
Okay. That's 1 in favor. Glenn?
I'll be in favor of granting it continuance.
Dave?
Yes.
Okay.
Yes. Granted.
Okay, so that was Debbie and that was Robin for the record, and I am also in favor. So the motion to grant the continuance has passed unanimously. At this point, Heather, what is the best way to discuss, to work on this, to discuss it?
It's got to be a date that works for the council, that works for the applicant, and that works for at least Mr. Moore at this point. We're going to try and, you're not going to necessarily be able to ask everybody about a date. So the dates you have available are December 14th is your next meeting date, which is not even 30 days. You have January 25th, which is the end of January, and your February date is February 22nd. We did, for other purposes, we already asked the Village Green about use of this facility on all of those dates, and it is available on all of those dates. So as far as the date, ma'am, can you please, we're trying to conduct the meeting and so that we can come up with the date. And so you can choose those dates based on keeping several things in mind. One is, you've granted the motion to continue, which means you want to allow them enough time to get their experts, but the developer has rights too, and they have a right to be heard in a reasonable period of time. So keeping all of those things in mind, you might discuss those upcoming dates as possibilities.
What is our business for the December 14th meeting at this point?
You have another special use permit.
Which one is it? Working. It would be really exciting to do 2 of these at once. Are we limited? Well, let's go through a bit more. We're going to ask these nice gentlemen what they think in just a second. Go ahead, Heather.
I was just going to tell you, he was raising his hand, so yeah, that's fine. It's not what you're going to ask for there.
Okay. So what I wanted to ask is, are we limited only to these dates? Now, it's a little crazy because we're getting close to the holidays here.
Right, the important thing is that we set a date and time today. We are not limited to those dates. However, it starts getting complicated because we're going to have to make sure we include the Village Green and everybody here involved in those dates. So as long as we can do it. Those are dates you know that are already on your calendar and are okay with the Village Green.
Yeah. Well, yes, sir.
How do we know how much time that the people withstanding need to get the information that they need so that they're on the same speed as these guys who have had extra time? I mean, I want this to be fair for everybody on both sides.
Yeah, and that's
so
how
I
I
heard
see it.
that, but I don't going to not give them enough time to figure out what they need.
And so that's what we have to do today. He's claiming that he's going to be injured for going longer than 30 days. These people claim that they can't have a fair hearing without more time. So we have to balance that.
Right, so how long does it take to get a traffic study? How long does it take to find out?
So would you like to ask the attorney for the motion, how long he anticipates it taking to get his experts?
That's fair.
John, please answer that question.
Yeah, I'm happy to answer that question. I think in the dates that were thrown out there in December 14th, or January 25th and February 22nd, in our motion, we asked for the 22nd or your February date. And the reason for that was because, as I indicated, I've already talked with experts in this area, and based on current availability, I don't anticipate them being able to assist before mid to late January. So, I mean, if there was a compromise to offer, I would throw out there the January date versus the February. But that's based on actual conversations I've had with experts in this area. It's just incredibly difficult with their workload and the holidays. I can represent, there is no way we would be able to retain the necessary experts if this was placed on the December 14th calendar. But perhaps that January, but I think ultimately our request is the February.
All right, thank you, John. Would you like to speak, or you like to speak to these possible dates?
Well, I was just going to say, you're not wedded to regularly scheduled meetings. You're able to set a special call meeting.
I'm sorry, Craig, I'm having a hard time hearing you. I apologize.
You're able to have a specially called meeting, is what I said.
He's just bringing up that we could have specially called meetings. Are you able to hear, John?
I could hear you. I'm sorry. I couldn't hear Craig. I'm sorry.
He was just mentioning we can have special meetings. Yeah.
All right. So I would just, again, well, I know Stephen wants to speak about the timing, so go ahead.
Please use. Yes, please.
We spent a year on this, and I feel like I spoke with them wrong. So it's very frustrating to get to this point and find out that we're going to be late. With that being said, I very much respect the comments that I've heard from the community today. And if I can address a couple of issues over the next few days with certain third parties, I would be okay with a January date, but not the end of January. I mean, that's a long way away. And John, there's a lot of experts out there. The ones you've talked to, maybe there's a lot of experts.
So you're saying, what would be a time frame in January that you
just, I'm not going to make, I don't want to argue, I'm not an arguer. The earlier in January we can do it, the better. It could be every week's going to matter at this point, so mid-January would be wonderful. The other thing I wanted to say to those who are concerned, I don't understand opposition when you don't know what it is yet. So those who are concerned and would like to sit down with me, and maybe some members of my team, or just me, whatever you want, I would love to do that. And we can do it sometime over the next few weeks. I thought I'd been very collaborative in this effort. Apparently, maybe I haven't done enough, but I can fix that now. So I would love to have a meeting with all of those that are concerned here under the COVID restrictions as soon as possible and address as much of the concerns as I can. Thank you.
Thank you, Steve. All right. So it seems like if the most reasonable compromise is that we try to schedule a special hearing earlier in January. John, would an earlier meeting in January be an acceptable compromise for you?
while I would love to be able to accommodate the council, I can only relay what I've been told by those experts, which is that, mid to late is when they're available. And to the applicant's comment about there's many experts, I can tell you from personal experience, there are very, very few experts in these areas that will work on cases related from the community or non-development side, because they risk not getting future business if they were to testify against a development project. And so I've had to rely on professors from universities and other things like that. So while there are a lot of engineers out there, there are not a lot of engineers that are willing to take this case from the community or adjoining property owners standpoint. So we'd ask, as the compromise, be the end of January versus earlier. I'll also say I have just a date to throw out there. I have a Board of Adjustment meeting in Buncombe County that's set for the 13th, which I would anticipate would take all day. So that's just one day I'll throw out there that would be, I would not be available if the council was inclined to do it earlier in the month.
Pretty much, John. I personally, I'm up for trying to meet in the middle, and I'd like to throw out this date of Monday, January the 11th. That's 2 weeks earlier than our regularly scheduled meeting. Would staff have a problem with that, or would any of the councilmen have a problem with that?
I cannot.
You're unavailable on the 11th?
I am. We've got other meetings set. We don't know our commissioner schedule. That's going to be set. Right now, Wednesdays, if available to the council, and that's a day that typically we don't have other county meetings.
Wednesday?
Wednesdays may be best.
Okay, so what if we looked at Wednesday the 13th? And this would be. Oh, that's the one day you can't use. I'm sorry.
That is absolutely, it will be a full day hearing in Buncombe County. I apologize.
The next one is January 20th, but then we're only giving 5 more days prior to our January 25th meeting. So the other thing we could look at is January the 6th. How many days is January the 6th from today? That is a month and a half. I think a month and a half is a reasonable amount of time to get some experts to hear your case. Do any of the other council members, any of you have a problem with January the 6th? January the 6th, a 9 a.m. meeting, staff? Would y'all have a problem with January the 6th at 9 a.m.? Okay, John, it seems like the consensus in the room is January the 6th at 9 a.m. Heather, do I have to order you? Are we going to order you or staff to prepare an order or to make this meeting?
Well, we will take care of that. We need to verify first if Bill Tree, do you have Ann? I'll have to make sure she's available. I'll do that here in just a minute. And then we need to set our time. We say 9 a.m.
9 a.m.
Mr. Chair, but just as an accommodation to the council, and it sounded like some logistics had to be figured out, I would suggest to the council that you could do this alternatively, make sure that there's not a notice issue to where you could say, we'll put this on our meeting for the 25th unless accommodations can be made to facilitate it on the 6th. I would just hate for a situation where meeting space or something else couldn't be brought together, if that's what I heard your attorney vocalizing, and then we have an issue of what day it's going to be.
Thank you for that, John.
That would work. You have to set it to
I think the consensus in the room is January the 6th at 9 a.m. And that would be the date for the continuation. Is that?
We were at 20. I think
so. Heather,
you're still right.
You're saying the 20th? Should there? I mean, what if there is a disagreement amongst the council about what is the most appropriate date? How should that be handled?
If you can all make the 20th, I'm trying to reach out to Ann now, and then have a vote between the 6th and the 20th.
Okay.
Okay.
All right. So can I have a motion to approve the 6th as the chance that people will have a chance to vote for it or against it. Do you have a motion to have the 6th at 9 a.m. be our next scheduled hearing?
I'll make the motion.
Do I have a second?
I'd second that.
Okay. All in favor of having the hearing be scheduled for Wednesday, January 6th at 9 a.m., please vote now. Okay, so that motion carries. So the hearing date, the continuance will be Wednesday, January the 6th at 9 a.m. What happens if this facility is unavailable, Heather?
We can go right now, find out.
At this point, the motion is passed. I'm trying to find her in her actual office.
Yeah.
She said either day they would accommodate.
Okay, so it's passed for the 6th, so we have it down to the 6th. Now, did I understand correctly, Heather, that since we opened the public hearing, we will not be accepting new applications for people with standing in between this date and that date?
Correct.
Okay, so if you have put in your application for standing, when we get back to this hearing on the 6th, we will hear and judge if you have standing at that point. Is that right?
Yes, on the 6th, on your continued.
Okay. Is there anything else we need to do to bring today to an end, Heather? No. All right. So today is over, and we will see you all on the 6th of January at 9 a.m. Thank you very much for your time.